Welcome to the MyLaw CLE presentation. During today's presentation, you may access the course materials from the handout section located on your screen. Attendees seeking credit for this presentation, pay careful attention to the screen. A pop-up box will be displayed at various times during the presentation. You will need to click Confirm on the pop-up each time it appears to qualify for CLE credit. In order to receive CLE credit, you must also click on the link that will appear at the end of this presentation to initiate the certificate process.
Welcome to today's webinar. My name is Debbie Brenneman. I'm a partner with Thompson Hine in our labor and employment practice. I am delighted to introduce Anthony McNamara, also in our labor and employment group, who will be presenting with me today. And a little later in the program, we will introduce you to two of our employee benefits attorneys. For the next 40 minutes or so, we will present key employment and benefit topics related to the American Rescue Plan Act that was signed into law in March. That will be followed, time permitting, by a Q&A session, so make sure to put your questions if you have them in the chat box. Thank you for your interest and attending today, and I will turn it over to Anthony to begin our program.
Thanks, Debbie. Good morning or afternoon, everyone, depending on where you are. It's definitely our pleasure to be with you today and to discuss all the ins and outs from an employment and benefits perspective with the American Rescue Plan Act that was recently signed into law. First things first, I know that we all know about the stimulus checks. We all know about the unemployment benefits that come with the act. But there's definitely a lot in this act that employers need to know about, and that'll be a big benefit to them moving forward. First thing is, we're starting to see what the Biden administration's focus is going to be. Well, let me correct that. We've known for a while now that the Biden administration is going to place an emphasis on workplace safety relating to COVID-19. We heard that throughout the campaign. We saw it with some executive orders that were put out shortly after he was sworn in. But now we're starting to see what that might look like. Importantly, within the ARPA is a $200 million allocation to the Department of Labor throughout some of its agencies, most notably at least $100 million being allocated to OSHA, with $5 million of that directly related to enforcement of high-risk workplaces such as hospitals, prisons, and food industry companies. But also within this is money that's going to the Wage and Hour Division, Mine Safety and Health Administration, the Office of Workers' Compensation Programs, the Office of the Solicitor. There's also money going to the Office of the Inspector General to oversee the Department of Labor's activities with regards to this money. So, we're seeing, what we expect to see is a lot more enforcement activities coming from the Department of Labor, most importantly through OSHA and the Wage and Hour Division, relating to compliance activities and how leave was administered under Families First and making sure that was done properly. So we certainly expect to see more of that here in 2021, 2022, and beyond. Another big piece of the American Rescue Plan Act was the expansion of Ppp loans. We weren't sure how much we wanted to talk about PPP expansion within this webinar, given the date of the presentation, mostly because the American Rescue Plan Act did not extend the application deadline past yesterday. However, recently Congress passed and President Biden just signed into law yesterday the PPP Extension Act, which now gives loan applicants until June 30th of this year to apply for PPP loans. And this is important, for small businesses and self-employed persons. If the money is used in accordance with what the program requires, this can be really free money. So definitely keep an eye on this. In terms of how the program was expanded, it was really expanded in two ways. First, there are now additional nonprofit organizations that are eligible for PPP loans. Initially, when PPP came out, it was just, I believe, 501c3 and 501c6 companies or organizations. When we got the stimulus bill back in December, that provided some more organizations that were eligible. Now we're seeing even more. Importantly, 501c4 organizations still are not eligible for PPP funding, but there are plenty of organizations that are. And that includes really any nonprofit organization under Section 501c of the Internal Revenue Code, other than those I just mentioned. So this includes fraternal organizations, some social organizations, veterans organizations, really sky's the limit from a nonprofit perspective here. The only requirements are for newly eligible organizations, they need to employ 300 or fewer employees at each physical location. They can't derive more than 15% of their receipts or devote more than 15% of their activities to lobbying. And they can't have exceeded $1 million in lobbying activity costs during the most recent tax year. The other big expansion piece was making internet publishing organizations eligible. Some very few requirements here. They need to be assigned the NAICS code here in the slide, and certify in good faith that they are an internet-only news publisher or periodical publisher, and need to be using the money for the part of their business that supports local or regional news. There's also, like with the nonprofit piece, an employee threshold here. It's 500 employees at any physical location is the max for internet publishing organizations. So that's, from a DOL perspective and a PPP perspective, some of the updates that are coming out of this law. I'm going to turn it now over to Debbie to talk about some of the extensions of tax credits that are also found here.
Yes, thanks, Anthony. So the ARPA also expands certain leave provisions of the FFCRA and extends tax credits to employers with fewer than 500 employees who voluntarily choose to provide continued paid leave coverage through September 30th, 2021. Of course, the mandate for that coverage expired on December 31st, 2020, although there may be some state or local laws that require continued coverage. But this allows for continued tax credits. So under the FFCRA, employers with fewer than 500 employees were required to pay that up to 2 weeks of paid sick leave under the Emergency Paid Sick Leave Act, and then up to 10 weeks of paid family leave under the Emergency Family and Medical Leave Act to employees who are out due to COVID-related reasons. And again, those requirements expired at the end of last year, but through the Consolidated Appropriations Act of 2021, employers could choose to continue to voluntarily provide those leaves and receive tax credits through March 31st, 2021. Now the ARPA further extends the tax credits to those employers who are going to voluntarily pay these benefits through September 30th, 2021. But this extension of tax credits brings some pretty significant additional changes to the requirements and the parameters of those two leave provisions. So under the Paid Sick Leave Act, ARPA resets the 10-day, 80-hour limit for paid sick leave starting on April 1st, 2021, today. So even if employees had previously exhausted their entitlements to paid sick leave under the FFCRA, they start anew. They have another 10-day, 80-hour potential for use if you, as an employer, are voluntarily providing that. Plus, under the original EPL SLA, there were 6 scenarios under which employees could take emergency paid sick leave, and those remain in place. Those are if the employee is subject to a quarantine or isolation order, if the employee's physician has advised them to quarantine or isolate, if the employee has symptoms, if the employee is caring for somebody who's under some kind of isolation or quarantine order, if they had to care for a child whose school or place of care was closed due to COVID-19 reasons, or if the employee was experiencing some other health-related conditions. Those stay in place, but there are 3 new scenarios for emergency paid sick leave and for claiming that tax credit, and those are seeking or awaiting the results of a COVID-19 test by an employee who's been exposed, or if the employee is required or requested by their employer to be tested, obtaining a COVID-19 vaccine, or if the employee has some side effects related to the vaccine and needs some time off to recover from that. In addition to these new qualifying leave reasons and the tax credits, the ARPA also requires employers voluntarily providing this leave to follow a non-discrimination rule. So if the employer is only extending the leave for certain categories of people, maybe excluding high compensation employees or making it available only to full-time employees, then you would not be eligible for the tax credit. It has to be applied on a non-discriminatory basis. Now, as of today, the ARPA also allows any of those expanded scenarios to qualify as reasons for Fmla leave. So previously, employees could only take that emergency paid family leave in those instances involving school and daycare issues related to COVID-19. As of today, if an employee takes the emergency family medical leave, the entire period of leave is paid, and they can take it for any of those reasons that are qualifiers under the paid sick leave. So an employee on Fmla now for the whole period would receive 2/3 of his or her regular rate of pay subject to the daily cap, and the employee would be allowed to take a maximum amount of $12,000. So this increases the scope and breadth of the Fmla as well. Now, in addition to expansions to the paid sick leave laws and those tax credits, there's also been an extension and expansion of the employee retention tax credit. So back when COVID first hit, in an effort to help employers keep employees on the payroll during the pandemic, Congress created the Employee Retention Tax Credit under the original CARES Act. And this created a refundable tax credit, gives eligible employers an ability to claim a credit against payroll taxes that they would owe for each of their employees. Originally, that was extended through June 2021, and there was some expanded eligibility. Now, under the ARPA, it's been expanded again through the end of the year, and the scope has been expanded to cover more employers and a larger percentage of the wages. So the Act has significantly broadened the scope of the gross receipts test for qualifying for the credit. This test generally requires the employer's receipts to have declined by a certain percentage when compared to receipts for the same quarter of 2019. For quarters in 2020, the decline had to be greater than 50%, but now under the ARPA, the decline must only be greater than 20%, so really broadens the scope. Gross receipts are generally going to include all sales, amounts received for services, income from investments and outside sources. Now, the next extension or expansion to the employee retention credit is that the original rules covering periods in 2020 provided for a 50% tax credit against certain qualified wages paid by employers. That credit was later expanded to 70% for the first 2 quarters of 2021. Now, ARPA expands that also through the end of the year. The maximum qualified wages are also increased from $10,000 in the aggregate to $10,000 per quarter. So all of this means that the credit increased from $5,000 per employee up to $28,000 per employee. The Act also raises the number of employees to qualify as a small employer from 100 to 500. Small employers may claim all wages paid during the eligibility period. Large employers can still take advantage, but they may qualify for the credits, but only with regard to employees who are not providing any services as a result of the pandemic. The ARPA also created a new category of eligibility for recovery startup businesses. And these are defined as businesses that started operating after February 15th, 2020, and whose gross receipts over a specified period are not in excess of $1 million. Those employers are eligible for up to $50,000 in employee retention credits per quarter. The ARPA finally increases the availability and value of credit to those employers defined as severely financially distressed employers. That allows such employers to take all wages into account, not just those that are paid for employees not providing services. So the ARPA extends the employee retention tax credit, again, through the end of the year. It also modifies that credit such that beginning after June 30th, 2021, the credit will be restructured as a refundable payroll tax. And the ARPA also changes the eligibility criteria by allowing severely financially distressed employers with more than 500 employees to include all wages, not just for the, for those employers not suffering from severe financial distress, to those employees that are sitting aside because of lack of work due to COVID. So great expansion with regard to these categories of employers, the dates, and really upping the amount of wages that can be considered in terms of qualifying for the tax credit. And with that, we're going to go into the employee benefits portion of our program. I'll turn it over to Kim Wilcoxon and David Eulendorf.
Thanks, Debbie. We'll move into the benefits portion of today's discussion. My name is David Eulendorf. I'm an associate in the Cleveland office of Thompson Hine in the Employee Benefits and Executive Compensation Practice Group. I'm joined today by a partner in our group. I will let her introduce herself.
Hi, I'm Kim Wilcoxon, a partner in the Cincinnati office at Thompson Hine.
Into the slides. All right. So some level setting today, and a little bit of a disclaimer. Our goal today is to provide a summary overview of the benefits provisions that are implicated in the American Rescue Plan Act, or ARPA, as we'll call it today. We also anticipate some significant and are hopeful for some significant guidance from the IRS and the DOL in the coming weeks. And as such, our discussion today may be impacted by that guidance. And Kim and I will try to highlight those areas where there may be some open questions that we're really looking for the regulators and to tell employers what to do. One other note before we get started, kind of in the same lane, we will reference probably repeatedly the American Recovery and Reinvestment Act of 2009. And this was a similar piece of legislation, provided a lot of different types of relief, but specifically for our purposes, had a Cobra subsidy. And after that, had lots of helpful guidance from the DOL and IRS. So if we can extrapolate that a little bit and kind of anticipate what the DOL or IRS might do, we will note that as well in today's presentation. So without further ado, what is probably considered the big ticket item from our perspective today is this Cobra subsidy provision that was in ARPA. So ARPA provides a full Cobra subsidy from April 1st to September 30th of this year for subsidy eligible individuals. That's 100%. When it was initially proposed in the House, it was an 85% subsidy. It went back and forth a little bit. When it was signed into law, it was 100%. So subsidy eligible individuals pay absolutely nothing for coverage from April 1st to September 30th. And then so the employer or insurance company, in some cases, who are bearing that cost will be responsible for recouping their that expense of the premium through a payroll tax credit. So what is a subsidy eligible individual? Well, there's several requirements that must be met. First, they must have lost their group health plan coverage due to an involuntary termination or reduction in hours. So applicable to medical, dental, vision, etc. Does not apply to flexible spending accounts or accepted benefits such as life, AD&D. The bold word there, involuntary termination, is really key. And as time permits, we will kind of dive into that a little bit more. But for now, let's think of that as your furloughs, your layoffs, termination for cause, although the federal Cobra statute accepts terminations due to gross misconduct. It's also kind of right off the bat one of these uncertainties right now and open questions. Does the involuntary termination, does involuntary also apply to reduction in hours? That's something we're kind of hoping for more guidance on, but just keep in mind that it's not all Cobra eligible events that will make an individual eligible for the subsidy. It is just the involuntary termination and reduction in hours. Secondly, individuals cannot be eligible for another group health plan coverage or Medicare. So if they have available coverage through a spouse or otherwise, they will not be eligible. And I think it's helpful to think about this from an initial eligibility perspective, but also if they are a recipient of the subsidiary and become eligible subsequently for group health plan coverage or Medicare coverage, then on that date, their subsidy would terminate. Third, they must be a qualified beneficiary, and Cobra defines a qualified beneficiary as a covered employee or a dependent or a beneficiary, excuse me, which would include a spouse or a dependent child. So any of those individuals would be considered subsidy eligible individuals. The Act also creates this special enrollment period for really two groups of people. The first being individuals who don't have Cobra coverage, but who could have elected Cobra coverage and would otherwise remain eligible for Cobra coverage as of April 1st. They have a chance to kind of jump in to Cobra coverage prospectively as of April 1st. The second group is actually individuals who did elect Cobra coverage and may have terminated that Cobra coverage prior to April 1st, but who otherwise would still be eligible for Cobra, meaning they wouldn't have reached their maximum Cobra period. Those people actually now have a second chance to hop back into Cobra continuation coverage as of April 1st prospectively at no cost to them. So why not? And I think Kim's going to walk through some examples for us to illustrate those points.
Yeah, we'll go through a couple of examples to see how this would work in real life. So let's say that Amy was involuntarily terminated on October 15th, 2019. So we're going back to 2019 under a plan that's subject only to federal Cobra. If she had elected Cobra coverage, she could have gotten up to 18 months, and her 18th month of Cobra would have been April of 2021. So under that second chance election that David just mentioned, she has the opportunity to elect back into Cobra, but only for April. So you can see here the depiction. We have our 2018, 2019, 2020, 2021 calendar at the bottom of the screen. And you can see that her 18 months starts in November of 2019 and ends in April of 2021. She would be eligible for the subsidy, assuming she's not eligible for other group health plan coverage or Medicare, for April. She doesn't get any extra Cobra coverage. So she doesn't get 18 months beginning in April. She just gets to finish out her 18-month period, and she gets to do it for free. Now, let's look at a plan that's subject to state continuation. So the Cobra subsidy law is going to apply both to federal Cobra coverage and also comparable continuation under state law. So let's say instead of being in that plan that was subject only to federal Cobra, Amy's under a plan that's subject to New York continuation, which is a 36-month continuation period. So with her now in this new plan, we're going to go back to April of 2018, long time ago. And she terminated in April of 2018. Her first month of Cobra coverage would have been May of 2018. She could have gotten up to 36 months, which would have ended at the end of April of this year. So if she was involuntarily terminated then, and she's ineligible for other group health plan coverage or Medicare now, could she get that second bite at the apple, that second chance election to get in for 1 month? Based on the wording of the statute, it appears not. It appears that this second chance election is only available to people who are eligible for Cobra under federal Cobra law. Now, although she would be eligible for the subsidy if she were on state continuation, it doesn't appear that she has an option to elect in. So that seems to be a difference between state continuation and federal continuation, and we're expecting the guidance that comes out to confirm that. So let's look at another example. Let's go back to 2019, or go forward to 2020. So let's say instead of terminating in 2019 or 2018, Amy actually terminated in October of 2020, and she's under a federal Cobra plan. If she had elected Cobra coverage back in October, it would have been effective November 1, going forward, past 2021. So she'd have her 18 months. She didn't elect Cobra. Assuming she's not eligible for other group health plan coverage or Medicare, she should have this opportunity then to enroll effective April 1 going forward. And if she enrolled April 1 going forward, she would have free coverage through September, assuming she maintained eligibility. And then she would get to finish out her Cobra period, but she would have to pay for that. So that's why the blue section is a different color, because once she gets past September, then she's going to have to pay for it. But Amy terminated employment during the outbreak period. And as many of you know, we have guidance that says during this outbreak period, deadlines have to be extended. One of those deadlines that's impacted by the outbreak period is the Cobra election deadline. So if Amy's Cobra election deadline would have been during the outbreak period, guidance from the Department of Labor tells us that we have to actually extend that deadline for up to a year. So Amy right now, theoretically, is still in her original Cobra election period. It appears that she would have this special election opportunity under the Cobra subsidy, but also her original election period. So could she have the choice to go forward from April 1 or to go retroactive back to November of 2020, pay all those retroactive premiums? That's, you see the dark blue box there represents the time we need to pay premiums. She would have to pay those retroactive premiums to catch up to Cobra to get it April 1 and go forward. So I think the way the law is written, the IRS would give her the choice between the two, but this interaction between the outbreak period guidance and the Cobra subsidy is something that we are really, really hoping the IRS and DOL address in the guidance that's coming out. And last example, let's say that Amy was involuntarily terminated again October of 2018. So if she had elected Cobra coverage, her Cobra coverage would have been exhausted in April of 2020. Clear that she is not eligible for the subsidy. She is not eligible for this second chance election. But what if she had covered her spouse on the date of her termination, and her spouse then also was covered under her Cobra coverage, and then they got a divorce during the Cobra period? That divorce would allow the spouse to provide notice to the plan administrator and get an additional 18 months of coverage. So in this example, the spouse could have Cobra coverage into April of 2021, even though Amy couldn't. Does that mean that an employer has to go back 36 months to find people who involuntarily terminated, figure out if they had second qualifying events during that time that would have encouraged their beneficiaries to have additional coverage? I mean, that seems like a lot of work that nobody wants to do. So we're really hoping the IRS guidance comes out to say, no, you don't have to worry about these, second qualifying event situations. So David, I'll turn it back to you.
Thanks, Kim. So in addition to the Cobra subsidy itself, there's a couple other requirements that employers need to be aware of. First and foremost, the required notices that come along with the Cobra subsidy. And ARPA really creates three new kind of notice requirements. The first being notice to subsidy eligible individuals who became entitled to elect Cobra prior to April 1st. So these are those groups of individuals we discussed that have that special enrollment period now, who weren't covered under Cobra or may have been covered but terminated their Cobra coverage, who are now going to get almost a second bite at the apple. That notice must be provided by May 31st. So we have 60 days from today. As if you didn't notice, the subsidy period starts today. But I will say too, the tolling period for the individual's election period of 60 days will begin when they receive that notice. So the sooner the better, but obviously we are waiting for DOL model notices as noted on the slide below. But in general, when those do become available, employers probably want to provide those as soon as possible so those election periods begin to toll. The second notice requirement relates to people who become eligible for the Cobra subsidy mid-subsidy period. It's basically a modified Cobra election notice that says you're eligible for Cobra, and oh, by the way, you don't have to pay for it until October. and that also is the normal 60-day election period. The final required notice would be notice to persons whose subsidy will expire for reasons other than eligibility for other group health plan coverage or Medicare. As we discussed, when someone becomes eligible for another group health plan or Medicare, they lose their eligibility. But we also are going to have to provide a notice to those individuals, that are going to be impacted by the expiration of the subsidy period. So that notice has to be provided no more than 45 days, but at least 15 days before the end of the subsidy. I guess that could also apply to a maximum Cobra period as well. Again, in all these cases, the DOL is required to provide model notices. For the election notices, we should have a model notice in the next 10 days or so. And then the expiration notice is supposed to be later this month. They have a little bit more time to provide that to us, but hopefully some of these model notices, as Kim alluded to, will answer some of these open questions. They're also have been directed to release some regulations in this regard, so more information to come. So we've kind of talked about what the Cobra subsidy is. How does it work? What's the mechanics? As I've indicated, assistance eligible individuals that elect Cobra pay absolutely no premiums during this period from April to September. That means that the employer, in most cases, is going to be bearing those costs in the meantime. The way they recoup that is by claiming a payroll tax credit for the amount of the Cobra premium that assistance eligible individuals otherwise would pay. So I'll make two notes here. One, this would apply to fully insured, self-insured plans that are subject to federal Cobra regulations. In the case of a small employer of 20 or fewer with a group health plan that is not subject to federal Cobra law, but who is subject to a state mini Cobra law, as we would call it, in that case, the insurer will be responsible for claiming that credit. The other really important thing that we want to note here, and it may deserve some further discussion, time permitting, is that employers are only going to get or they are likely only going to be able to get to reclaim the amount that otherwise, the individual would have paid. So, for an example, if you have a severance arrangement or it's just policy that you subsidize coverage, let's say 50%. Well, now that it's 100%, you're probably not going to be able to get a credit for that entire 100%, because absent the Cobra subsidy, you'd still be bearing 50% of the cost. This is based on the 2009 Act, and I think it's something we anticipate will likely be the same, although I would note there are organizations that are lobbying and asking for that not to be the case. In 2009, I think we had a 65% subsidy. This time we have 100% subsidy. So there is some distinction. So that is definitely an area to keep an eye on when additional guidance comes out. As obviously employers will care how much of this money they can recoup, especially since the costs for Cobra probably far exceed 102% they're permitted anyways. Oops. So then the kind of other half of this Cobra subsidy provision, besides the Cobra subsidy itself, is this plan enrollment option. And again, this is an optional election change that would permit employers to allow assistance eligible individuals to switch to a lower premium plan option. They would have 90 days from the date of notice, and they can switch to a cheaper coverage option. Now, this was in the original bill when it was introduced, when it was still an 85% subsidy. So it may have had an increased, I guess, utility because the employees or the individuals were still responsible for 15% of their Cobra premiums. Now they're responsible for 0. So from April to September, this would have no impact to them. But after September, as we kind of walk through in some of those examples, these individuals will be required to, presumably be required to resume paying for their Cobra continuation coverage. So there may be some utility here still. Time permitting, we may talk about what goes into that decision from an employer perspective of offering this or not.
So to sum up the discussion we just had, oops, and I'm getting slide happy here. What are some issues, what does all of this mean for employers? Well, first off, as David mentioned, we are waiting on guidance. Absolutely, we need more guidance to know exactly how this is going to apply and to impact you and what's going to be required. But in the meantime, you can get started trying to identify the eligible population. Which of your employees were involuntarily terminated? Which of your employees, had reduction in hours that caused them to have a loss of coverage? And what do we mean by involuntarily terminated? Do your term codes cover involuntary termination for cause, involuntary termination for layoff, some of the other involuntary termination types that we might see under this guidance? You want to be sure you understand what term codes you've used in the past so that you can determine whether the research that you do to gather the eligible individuals is going to be accurate. And then you also need to consider how far to look back. And again, I think we need guidance to really confirm. Clearly 18 months is going to be safe, but do you need to go back further for any other circumstances? You'll also, as David just mentioned, want to decide whether to implement this option that would allow individuals to switch into a lower premium option. It is not required. It's completely permissible, just something for you to think through. You'll also want to consider whether to amend severance programs to remove a voluntary subsidy during the federal subsidy period. If guidance comes out to say that you can't take the full tax credit for any amount that you voluntarily subsidize, any agreements you've already made to someone to subsidize their coverage, you probably can't take back. But for terminations that occur in the future, it may be worth looking at your severance program to modify that to see if there's something you could do to make sure you get the full tax credit. And I've had a number of questions from employers who are getting questions from people who were just laid off or other employees who have heard about this. They feel the need to really want to tell people what's going on right now, and that's understandable, but we don't know really what's going on until we get the guidance, until we get the model notices from the DOL. So you'll want to consider, should you give people a heads up that more information is coming? And if so, keep it as brief as possible so you don't say something that turns out to be wrong later on. And of course, you're going to want to coordinate with your Cobra vendor, understand what their timing is, what services they are willing to provide as part of this. Are they updating notices? Are they, going to send out notices for you? Or what are they expecting of you? Definitely want to understand, what the partnership is with your Cobra vendor. And then, as David mentioned, we're going to recoup the cost of the premium, but the cost of Cobra coverage is so much higher than the cost of the premium. You may want to consider, especially if you're a public company that needs to report financials, what sort of impact is this going to have on your claims experience, if that's something you can even estimate at this point in time. But it's definitely something to consider. And watch for guidance, watch for guidance, watch for guidance. So with that, we'll transition to other aspects of ARPA, the first being an increase to the dependent care FSA maximum. So the ARPA said, essentially, the maximum amount that can be excluded from an individual's income under a 129 dependent care assistance program is going to be increased from $5,000 to $10,500. What does this really mean? Some employers have looked at this as, great, we can increase the amount that an employee can contribute to an FSA. Other employers said, great, we don't have to worry about the tax consequences of our new carryover plan. And I'll do an example here to explain what we mean here. It's not entirely clear what the purpose of this was, but the tax consequence is something to pay attention to. So let's say an employer does adopt the unlimited carryover. So any unused funds from 2020 are going to carry over to 2021. An employee has $3,000 remaining in 2020. They elect to contribute $5,000 in 2021, which means that $8,000 is available in 2021. Now let's say they also receive $6,000 in reimbursement, which means they're going to have $2,000 at the end of 2021 to carry over to 2022. Then they contribute $5,000 in 2022. $7,000 is available for reimbursement. They get all $7,000 in 2022. What does this mean from a tax perspective? In a normal year, you can only get up to $5,000 tax-free. for 2020, because of ARPA, we now can get $10,500 tax-free. So as a result of this carryover, if we haven't increased the contribution limit, we can see in 2021, we have $6,000 of reimbursement, which is below our $10,500 limit, and none of that's going to be taxable. But in 2022, because this relief is only for 2021, we still are allowed to have the carryover, but we don't have an increase in the non-taxable maximum. So we're going to have $7,000 in reimbursements, which is $2,000 higher than the maximum amount we can provide tax-free. Does that mean that that $2,000 is going to be taxable in 2022? There's some uncertainty about that, and we're really expecting the IRS to provide guidance to confirm. Now, if an employer, though, decides to increase the reimbursement limit to $10,500 for 2021, that could end up with additional tax liability in 2021. Because in the example here, as you can see, if we increase the contributions, we could also increase the reimbursement. So we're getting more reimbursement than $10,500 in 2021. Does that mean that excess is taxable? We need the IRS to tell us to confirm. With that, I'll turn it back to David.
Thanks, Kim. And I think we want to leave some time for Q&A at the end. So a couple more topics here that we want you to be aware of, but we'll probably move through these pretty quickly. First, the pension plan funding relief. I'll say, at the outset, I am not an actuary. This relief, it involves very complex actuarial calculations. So I'll do my best to kind of explain them just so we are aware of them, and we are equipped at least to talk with our plan actuaries and counsel regarding these decisions. So there's pension plan relief in ARPA for single employer and multi-employer pension plans. So for single employer pension plans, there's really two key pieces of relief. The first being enhanced smoothing of interest rates that are used to calculate minimum required contributions. So and all this relief really goes to the minimum required contribution and trying to alleviate some of those cash flow issues for plan sponsors. So in general terms, the minimum required contribution is based on interest rates that actuaries will use to determine actuarial or present value of future payments. So in simplest terms, the way this has worked is that if you have high interest rates, you have low present value, you have low minimum required contribution. Well, fortunately or unfortunately, we've had a record low of interest rates for a while now. That's put a lot of pressure on these plans. What ARPA does is it extends and modifies the smoothing of these interest rates that are used to determine pension liabilities and really will lower those contribution requirements. This piece is applicable to plans generally in 2020, but plan sponsors have the option to choose not to apply it to any pre-2022 plan year. The other piece of single employer pension plan relief is this extended amortization of funding shortfalls. So the minimum required contribution generally amounts to two amounts. The plan's target normal cost, which is like your accrued benefits, any additional plan expenses incurred during the year, plus what is called the shortfall amortization charge. This is really the underfunded amount that you're trying to make up. What ARPA does is it kind of erases that in a way and says, okay, you're going to get a fresh start. We're going to recalculate your shortfall amortization charge anew. And instead of requiring you to pay that back over 7 years, as it was previously required, we're going to extend it to 15. Again, this is going to result in more stability and lower contributions. This is effective for the 2022 plan year, but plan sponsors can elect to apply it as early as 2019. Again, the bottom line is it's more flexibility. It can help ensure the survival of not only the pension plan, but also the employer. And the one other thing I would note about it is that you may want to consider any impact to your annual funding notice as a result of whatever approach you take with your plan actuary. Review your annual funding notice again and determine if there may need to be some additional disclosures or some changes based on those decisions. The multi-employer pension plan relief, to the extent we have participating employers or participants in multi-employer pension plans or attorneys with clients that are multi-employer pension plans, kind of highlighted the three big items here from ARPA. The first being a new financial assistance program through Pbgc for severely underfunded plans. This is for your critical and declining plans. There's going to be a separate fund at Pbgc that there's an application process for these plans. There's criteria that needs to be met. The Pbgc will make a determination whether you are qualify for their financial assistance. There's some caveats that come with that. If you qualify, you may have to restore certain benefits that have been suspended, things like that. But be aware that that is a tool that is out there. Second, we have the temporary freeze of current zone status for certain multi-employer pension plans. So probably familiar that multi-employer pension plans, based on how underfunded they are, have different categories. This actually allows them to take their current funding status and roll it over for the next 2 plan years, regardless of their actual funding status. The last bullet there, extension of current funding improvement and rehabilitation plans. So if you work with plans or if you have a plan that is in a funding improvement and rehabilitation plan, ARPA can extend that improvement and rehab plan by 5 years. So I think depending on your rating, it could go from 5 to 10, or 10 to 15, or 15 to 20 years. The last benefits related item that we wanted to discuss really quickly here is the expansion of 162M. This applies only to publicly held corporations. For those of us that are not familiar with Code Section 162M, it basically acts as a cap on employer deductions for compensation paid in excess of $1 million to what is called covered individuals. Before ARPA, those covered individuals generally included your CEO, your CFO, and your top 3 highest paid executives. And you may remember back in the Tax Cuts and Jobs Act, it was kind of changed how this group was treated. It used to be, every year you're looking at this CEO, CFO, top 3. Well, now once you're identified as one of those, you're always in. So that was pre-ARPA. Post-ARPA, beginning in taxable years after December 31st, 2026, so 2027, this acts to expand that group even further by including the next 5 highest paid employees. And that's employees, not executives. So this will include non-executives. However, unlike the pre-ARPA group, like I said, that it's once you're in, this group, you can come in and out. It's looked at on an annual basis. What is one group of top 5 one year may not be the same top 5 of employees the next year. As I mentioned there, this isn't effective until 2027. It doesn't change anything until 2027 at least. And the only reason we mention it is that it's something to be aware of, and it may drive or impact compensation decisions, arrangements that are entered into over the next 5 or 6 years, to the extent it's applicable. So I think that's the end of our prepared materials, and we'll open it up to Q&A. And if there are Q&A from the audience, I will take those first. Otherwise, we can move into some that are previously prepared.
So, David, I know you're reading that question. I've already had a chance to think about it, so I'm going to jump in. Okay. We had someone ask, if an employee terminates on April 15th, 2021, and has a spouse eligible for Medicare, clearly no Cobra subsidy applies for spouse's medical coverage, but what about a subsidy for dental coverage for the spouse? Medicare does not include dental coverage. Would a subsidy apply for dental for the spouse? That's an excellent question. And hopefully IRS guidance will touch on that. I was just reading through the 2009 guidance to see if there was any hint there. And I would guess that if they're eligible for Medicare, they're not eligible for the subsidy for any type of group health plan coverage, even though Medicare covers only medical. So again, when the guidance comes out, you could tell me I'm totally wrong, but that would be my crystal ball. David, do you want to take a question next?
Yeah, I think the next question that I see is labor and employment related.
Yeah,
ESL.
I saw that one, David. So one of our participants would like to confirm whether there is a reset of emergency paid sick leave. So if an employee has already exhausted the first bucket, the 10-day, 80-hour bucket of emergency paid sick leave that came under the FFCRA, do they get a reset? Do they get an additional 10 days, 80 hours under ARPA? And the answer to that is yes. It says that time will be reset, and the employee is eligible for that all over again if you choose to participate and provide these benefits on a voluntary basis. What's less clear and troubling is there also a reset on EFMLA? Which of course provides a longer period of time. Guidance by the DOL under the FFCRA, and we have all kinds of acronyms here, but guidance there was that use of FMLA for non-COVID related reasons counted against the emergency FMLA and vice versa. But some commentators are saying that because the language of this act does say that employees would be eligible for up to 12 weeks of EFMLA, that may support a reset of that more extended leave as well. So clearly, I don't think that makes sense, but there's somewhat of a disagreement about that. And we hope that there will be some guidance by the DOL very soon so that we have a better picture of how that will play out. And perhaps there's another benefits question?
We have a couple questions coming in right now. So there's a question: if someone elected Cobra in September 2020, are they now eligible for the subsidy for the next 6 months? So I think with that question, I mean, it depends on a couple things, I guess. But generally speaking, if you have your, your typical case, you have someone who has elected Cobra in September of 2020, assuming they're still paying for, in Cobra coverage, effective April 1st, they're automatically, no longer going to be paying those. The employer can no longer pass along those costs that they otherwise would, and that will be for the next 6 months. And I will say, there are other reasons someone could be on Cobra. We have to remember the subsidy only applies to individuals who experienced an involuntary termination or a reduction in hours. So hopefully that answers that question.
And then the next question, what about those participants that are already receiving the healthcare tax credit from the IRS? ARPA provides that if someone is a subsidy eligible individual for purposes of the Cobra subsidy, they're not eligible for the healthcare tax credit. So there would be no double dipping there.
I know. Oh, go ahead, Debbie.
Another question that came in was, can an employer choose to provide just one or the other of the paid leave benefits? Can an employer offer just extended emergency paid sick leave, but not EFMLA or vice versa? That's also unclear. The Act does not speak to that, so that's another one to stay tuned, and we hope that we'll get some additional guidance from the DOL.
And Debbie, I'm seeing a question as well about what does obtaining immunization mean as one of the new, means by which somebody may be eligible for leave if the employer wants to provide the tax credits. Again, I think the common theme here is that we don't know. We are waiting on the guidance from the DOL. Does that mean just the time waiting in line at the vaccination site? Could it be interpreted more broadly to include time spent trying to book an appointment? We don't know at this time. So we're hoping to see questions like those get answered within the interpretive guidance we expect to receive.
And we received another question. If they took a retirement package, that would be considered voluntary and not involuntary, correct? Well, that's a great question. And as we alluded to earlier, the involuntary termination is really an area that we're hoping to get more guidance on. The Act itself does not define what an involuntary termination is. If we rely on 2009, at that time, the guidance indicated that it's a facts and circumstances analysis. So in a situation where someone receives a package to voluntarily terminate, It depends. You know, it may be viewed as depending on the package. So there was guidance in 2009 that said if you have a material adverse effect, for example, that could come back and say, you know what, that really wasn't a voluntary decision. We offered you, you know, X amount of dollars to leave voluntarily, so you quit. That could be viewed as an involuntary termination. So unfortunately, I think we're gonna have to wait for more guidance to answer that definitively. And even then, it may be a facts and circumstances based analysis. And one other thing that's kind of added to this is in 2009, there was a provision in the act that provided for an accelerated appeals process to the DOL, and then employers could rely on that. It doesn't appear that we have that in this go around. So one of the highest areas of priority, I think, for the DOL and IRS, hopefully, is to set parameters on what involuntary termination. And while we're on that, there's other unique circumstances that are probably worth mentioning. Death, for example, in the last time it go around in the last act, that was not considered an involuntary termination. You could have an individual, I think I alluded to this earlier, who terminated for gross misconduct under federal Cobra. That would make them not eligible for Cobra coverage. But if you have state mini Cobra continuation coverage where that's not excluded, you might have an issue where that is, you know, that individual would be considered an assistance eligible individual. So really just want to highlight the fact that it's going to be probably facts and circumstances based. Hopefully we'll get some helpful guidance from the DOL IRS, but you definitely can't go into situations and see you know, they left voluntarily or involuntarily or let go and make a conclusion based on that.
Next question, the Cobra 100% subsidy applies to medical, dental, and vision, or just medical? It applies to medical, dental, and vision. It doesn't apply to healthcare FSA coverage, but it does apply to the other Cobra coverage.
There also seems to be a question: can employers choose to extend the paid sick leave and the paid FMLA to only full-time employees? No. You know, I think as Debbie mentioned, there is a non-discrimination rule that renders employers ineligible for the tax credits if their policies, you know, favor highly compensated employees, full-time employees, on the basis of tenure, anything like that. So it needs to be all-encompassing.
Another question that has just come in is, does ARPA simply extend the FFCRA? The answer to that is no. That the FFCRA expired. This simply provides tax credits to employers who choose to voluntarily provide those types of benefits to their workforce, but it is not an extension of the FFCRA.
Tim, it looks like we have another question. Will the subsidy cover the additional 2% Cobra administrative fee? Do you want to take that one?
Yes, it should, because the Cobra subsidy is going to be equal to the premium that the individual does not pay. And so if the individual is required to pay 102% of the coverage and they don't, you know, that 102% the employer will get to recoup. What would be interesting to see is, you know, let's say you're a self-funded medical plan, right? So you don't have to pay your Cobra premium to an insurance company. You're simply just going to eat the Cobra premium. But you have a Cobra administrator who gets paid to administer your Cobra, and they collect that 2% administrative fee as part of their compensation. Is there going to be an arrangement worked out where the employer then has to pay that 2% administrative fee to the Cobra administrator so they'll continue to provide services and while they recoup their tax credit? I'll be interested to see how that works out.
And it looks like we are bumping up against the end of our hour. I want to remind everyone that today's webinar was sponsored by MyLaw CLE. The presentation will be available on demand on the MyLaw CLE website. And on behalf of all the presenters, we would like to thank you for joining us today. We hope that you found the information to be useful, and we hope that you have a great rest of your day. Thank you.
As stated during the beginning of today's presentation, the link to initiate the certificate process will be displayed momentarily. My Law CLE would like to thank you for your participation in today's presentation.